Hey, thanks for joining me today on our special 4 p.m. Saturday time where we have Gen Taub Live. And today's show is going to almost entirely, but not entirely, focus on my hero and friend, E. Jean Carroll. Of course, the timing of this episode is the day after E. Jean Carroll appeared in federal court at the Second Circuit Court of Appeals in Manhattan, and that is a U.S. federal court. And she was there with her fabulous attorney, Robbie Kaplan, in the posture of essentially defending at least essentially the first verdict that she received in the case we call Carroll 2. I'll explain that why later. But this was the first case that was tried, and it was tried in the spring of 2023. And this is where a jury decided that Donald Trump had sexually abused E. Jean Carroll and that he had defamed her, that this sexual abuse had happened in that dressing room at Bergdorf Goodman in 1996, and the defamation in November of 2022. Again, this was the first case that was tried. This is the case for which the jury awarded E. Jean Carroll over $5 million in damages, including compensatory as well as punitive and so on damages. Okay, so E. Jean Carroll was in court yesterday. And I want to do something, hey guys, I want to do something original here. So let me tell you what the show is going to contain. First, we are going to look at Anderson Cooper taking down, demolishing the BS that Donald Trump was spewing in a press conference after court yesterday. Now, to be clear, I hate to play anything that Donald Trump says. And so I'm choosing only to share with you the parts of his crazy press conference that were dismantled by Anderson Cooper. But there was nothing else that he said that was truthful. And most of what he said was absolutely appalling. And we will get to that. But after we do that, guys, I'm going to do something you've probably never seen anywhere else. I am going to play for you, while I show you the photos of the lawyers and the judges, the oral argument yesterday. We're going to walk through it, and I'm going to stop it if it gets confusing, because I want you to see what the legal issues are about when you get to the appellate level. This is not any longer a do we believe E. Jean Carroll? No, this is not a question of the facts. This is very arcane arguments that only people who have very expensive, very smart lawyers take up to the courts like this. And honestly, if you listen to this on your own, even if you were a law student or a law student or a law professor or a lawyer, it would be baffling because you hear these voices and people are throwing citations and numbers out from statutes. But that's not how you should do it. I'm going to walk you through, and it's going to be crystal clear. And you're going to understand why people like Donald Trump, these white, wealthy, well-connected men, keep getting away with this crap over and over and over. Because they exploit the fact that they're willing to throw endless dollars behind their lawyers so they can get away with almost murder. And in the process, by the way, after this hearing, of course, and Donald Trump was silent at this hearing, just like he was silent in this particular first case that E. Jean won against him. He then, the coward that he is, will speak publicly outside of the confines of a courtroom where there is decorum and rules of evidence and you can't lie with impunity. And so I want you to compare and contrast that. So guys, like I said, hey, Susan, hey, Deb, hey, guys, thank you for being here. Okay, so let's start first with a little notion before we jump into that Anderson Cooper takedown of what this case I am talking with is about. Okay, so let me actually make this so you can see it. You can see it better. Okay, the case that was being argued yesterday was the E. Jean Carroll versus Donald J. Trump case. This was the first case that E. Jean Carroll brought against the first case tried against Donald Trump. We call it Carroll 2 because it was filed second. This is a case that was heard in the spring of 2023. And again, it was a civil trial in which E. Carroll successfully proved that a jury affirmed it, that Donald Trump had sexually abused her, which is, I don't want to get too much into the details, but this was a sexual assault that transpired in Bergdorf Goodman in department store dressing room in 1996, in which he penetrated her with his fingers. I have to say that because sexual abuse sounds too vague. This was essentially a rape, and it's what the judge in this case said was rape. Okay, now this is the case that was heard yesterday was Donald Trump's appeal. And you don't just get to appeal because you don't like something, right? On appeal, in this federal court, when you appeal, you are appealing decisions, legal decisions made by the judge. So in this case, to be clear, what Donald Trump was appealing, and you can see this, is as follows. And this was in his initial brief. Some things changed, and that's interesting. He is complaining that Judge Kaplan messed up. Specifically, the first thing he says, and this is me paraphrasing it because Donald Trump's lawyers threw in a bunch of defamatory statements that I don't feel like repeating. He was unhappy at the evidence that the judge let the jury hear. He was unhappy about some of the evidence the judge blocked the jury from hearing. And then overall, he thought that the cumulative effect of these errors meant that he essentially, that the cumulative effect of this resulted in Donald Trump's rights being violated, and he deserved a new trial. Now, to be clear, he also complained in this last part that the judge's rulings hamstrung Donald Trump's ability to testify. Okay, so what did they say that the judge allowed in that Donald Trump did not want in? Well, they think that Judge Lewis Kaplan should not have admitted evidence of other acts of sexual assault because he thought those were not connected enough to what happened to E. Carroll. So if you're trying to show that, look, and in particular here we're talking about his assault of Jessica Leeds on an airplane and his assault of Natasha Stoynoff at Mar-a-Lago. Okay, and as well as the Hollywood Access audio tape. All those things, they are specifically saying Judge Kaplan should not have let the jury hear. And their argument is that these are just not connected enough, and that they brought these two witnesses and the video in to show that he had the propensity to commit these kinds of crimes, and that should have been excluded under the rules of evidence. Secondly, and the evidence that they think Kaplan should have let the jury hear, they wanted to be able to cross-examine E. Carroll about what they claim was perjury during her deposition and other evidence pointing toward her bias and motive to lie. Specifically here, I think they're talking about wanting to refer to people that she associates with or people who were helping fund the lawsuit. Okay, so essentially, guys, this is what this appeal is about, just so you know. Now, before I get into that, I really want to show you first the BS that happened outside the courtroom, because I think you're hearing, sorry, my back keeps getting stuck to my chair. I think you've seen probably a lot of trolls on Twitter accusing, hey, Rosanna, Michigan, yes. Okay. So guys, I can't be doing this like this is a serious thing and I'm just like, hey guys, and then I'm talking about this. So I will check back in the chat in a moment. So one of the things that the Twitter trolls are often doing whenever you talk about E. Carroll's case is they try to lie and try to play into tropes of things like, what they always say about women, she was asking for it and so on. And they keep referring back to an interview that E. Carroll did with Anderson Cooper. And I, watched the interview as soon as people were mentioning it. And it was nothing that the MAGA trolls or Donald Trump was saying and said. But many of you probably have not seen it or seen Anderson Cooper stand up for E. Jean Carroll and set the record straight. So I'm going to play this for you and I'll pause. It's not super long. I'll pause in the middle so we have a chance to sort of check in on it. Okay, and let's do it.
Other thing that Donald Trump said today that I want to point out, because it kind of involves me, and he seemed to imply something that is unfounded. He was talking, as he has before, about an interview that E. Jean Carroll did with me back on June 24th, 2019.
Then there was an Anderson Cooper interview where she said essentially, no, he didn't rape me. She was selling her book. She wrote a book. The book would have been a total failure, probably was anyway, although probably sold more recently. Again, there's a woman that wasn't doing well until she came out with this stuff about me. And that's happened to others too, by the way. She's not the only one. But they have the Anderson Cooper tape. And in the Anderson Cooper tape, it's an interview of her. And Cooper says something to the effect, did he rape you? Did he rape you? He was so happy. Oh, did he rape you? And she gave a very good answer from me.
Can I just say he's such a disgusting pig? That's my legal comment. Okay, I'm going to keep playing it.
But a bad answer for CNN for Anderson. And he said, we're going to commercial break right now. We're going. Then she came back from commercial break, and she was much more hostile. But this man wouldn't let us use the tape or the proper questions having to do with the tape. Wouldn't let us, the judge.
This is such bullshit.
Judge Kaplan wouldn't let it be used. We wanted to get the outtakes. In other words, what did Anderson Cooper talk to her about during that?
Okay, so remember just a couple minutes ago when I was saying what was in his brief and he was complaining the appeal is about the argument that Judge Kaplan let things in that should not have gotten in. Again, the testimony of other women he sexually assaulted in the Hollywood Access tape and the stuff that they also objected to the fact that they excluded evidence and they claimed that she committed perjury. This is what they're talking about. They wanted to play the Anderson Cooper tape to the jury. So let's continue this. And it wasn't what he's saying. So let's keep listening.
Intermission for a commercial that he called for immediately. Where do you see this? I mean, some of you have seen it, some of you haven't. We're going to commercial break right now. And so what happened is we weren't able to use it.
Okay, so this is not the first time that Trump has seemed to suggest some nefarious plot by me to manipulate E. Jean Carroll into saying something. He actually brought this up in a deposition for trial. Now, I normally don't respond to when Trump says something about me. I mean, what is the point? He recently referred to me using a female first name, which I guess is like a third-grade gay taunt. I think he called me Allison or Ashley Cooper. I don't really recall. It's not worth replying to. But this time, it's kind of different because it's just demonstrably false.
I am so glad Anderson Cooper decided to do this. This is huge. It shows, I do think of him as honorable and good at what he does, but I don't always think CNN follows suit. So let's continue to listen.
First, I just want to show you what it is he's rambling about. This was part of my interview with E. Jean Carroll that took place on my show on CNN in 2 blocks, 2 segments separated by a commercial break. Now, this is what you would have seen if that night you were watching at home or wherever, and we went to commercial and then came back from commercial. We're not going to actually play the entire commercial break you would have been watching. So take a look.
I was not thrown on the ground and ravished, which the word rape carries so many sexual connotations. This was not sexual. It hurt.
Well, I think most people think of rape as it is a violent assault. It is not.
I think most people think of rape as being sexy.
Mm. Let's take a short break.
Think of the fantasies.
Mm. We're just going to take a quick break. If you can stick around, we'll talk more on the other side.
You're fascinating to talk to.
I love E. Jean. Love her.
Cancer is the ugliest disease mankind has ever faced.
I'm going to cut the commercial. He said there wouldn't be one.
Mankind has ever faced.
We're now in my conversation with E. Jean Carroll and the president's latest denial of her sexual violence allegations against him. He said, quote, "She's not my type." He's also said previously he did not know her, had never met her, even though they had, in fact, met. She's the one on the left, along with her husband, a local news anchor at the time, and the president's wife at the time, Ivana. The president has also said flat out that she is lying. Okay, so that commercial break, which we only just played a snippet of the commercial, ran 4 minutes long. So the former president seems to be suggesting that something we discussed, or that I discussed with E. Jean Carroll during a 4-minute long commercial break that you would have been watching at home, made Ms. Carroll change her tone toward him. Not sure her tone actually changed in the second block of the interview, but that's besides the point. The problem with this conspiracy theory is that this interview was actually pre-recorded, and we had to pre-record a toss to a commercial break and then welcome viewers back after a commercial break so that the entire 2 parts of the interview would fit into my show that.
Did you hear that? There was no conversation. I mean, I think you know this, that things sometimes play as live that are not live. Sometimes they pre-record because it's hard to get somebody, and then they play it. And then again, when you're being interviewed, they say, okay, we're going to just take a pause, and this would be when the commercial will go, and then you continue. Just to be clear, we are actually live right now. Okay, let's continue with this.
Night. So when you do that, when you interview someone for however many minutes, and then you toss to a break that'll later be inserted into the broadcast, you don't sit there for the entire 4 minutes of the commercial break with the guest just waiting to then come back to the show.
Of course not.
Because it's pre-recorded, you don't have to sit there during commercial break. You just take a few seconds. You make sure the control room is still recording. You welcome viewers back as if you've just come out of a commercial break, and you continue with the interview. And that's exactly what I do with E. Jean Carroll. And I know this because we have the tape. So while Trump is apparently suggesting I sat through a commercial break on live TV with E. Jean Carroll, telling her to be angry or whatever, we actually just paused in a pre-recorded interview for a few seconds. And if you don't believe me, here's the raw, unedited video of what was actually being recorded, and you will hear exactly what I said in the few seconds it took me to resume the interview. We're going to take a quick break. If you can stick around, we'll talk more on the other side.
You're fascinating to talk to.
All right, so we good? We coming back?
Yeah, right back up. Stand by.
Okay. So before the break, you said you don't use the word rape. So that was the entire break. So when Donald Trump was saying it was a 4-minute break, that I'm talking to E. Jean Carroll, you just saw the break. And that weird look I have is how I could talk to my control room, because when I'm saying, okay, we good, we coming back, okay, I'm talking to a producer in the control room who's talking to me in my earpiece right.
Okay, so now you know. Now you know she never said that she wanted to be raped. She never said that she thought rape was sexy. She thinks it's violent, but she's talking about what other people view it as. Okay, so yeah. So Donald Trump gave that press conference yesterday and repeated some of the same things. Again, let's just go back to this, that that the lawyers are arguing for him. Okay, so let's be clear. Yesterday was an appeal. Donald Trump is unhappy. This was the first case that was tried, finding him liable for sexual abuse and liable for defamation, resulting in a verdict of a little over $5 million. So he doesn't like that, but just because you don't like a verdict doesn't give you grounds for appeal. So the appeal to the Second Circuit, as mentioned, is based on, at least in his initial brief, was based on he was unhappy that the judge allowed evidence from other people who were assaulted in the Hollywood Access tape. And I say unhappy, and I'm going to get into the legal standard, he was also unhappy that Judge Kaplan refused to allow this Anderson Cooper interview in, and other things that they thought would show that she had perjured herself. And finally, overall, they think he is entitled to a new trial. Now, I just want to be clear to you, I keep saying he didn't like it, but on appeal, in order to, generally speaking, for an evidentiary, if you're trying to overturn a verdict based on the judge letting in or excluding evidence, the judge ruling on what evidence should or should not come in, the appellate court doesn't look at this with fresh eyes, doesn't look at it in a standard that we call de novo. they have to ask really whether this was the kind of error that deprived that any of these pieces of evidence, that letting them in or not letting them in, that it was clearly erroneous. Not like that they may have made a different decision or that it's a close call and they would have made a different call. It had to be clearly erroneous, and it also had to affect the jury's decision in the appellate court's opinion. So that is, that's what we're looking at here. Now, what was E. Jean Carroll's initial reply brief? They only said there was one question, and it was really just whether Judge Kaplan had committed such extreme abuse of discretion. And I'm sorry, I call it clearly erroneous, but I meant to say, to be clear here, another way to look at it is that he erred in such a way that it was an abuse of his discretion in his evidentiary ruling as to affect Trump's substantial rights and require a new trial. That what he let in and what he refused to let in as evidence, that his mistakes of law were such an abuse of discretion that it had to be overturned. Now, let me just, I'm going to go back to, I don't want to put this here. I'm going to now let you hear for yourself this. As I said, people don't usually do this because it's usually too complicated, but we're going to listen to the oral argument. It's not super long, but this is what we're going to do. Then after that, we will do one quick update and Crazy Town. Okay, so I want to make sure I don't play the Crazy Town music, but I play this case. Let's do it.
Trump, that is 23-793. Mr. Sauer, is that correct?
Yes, Your Honor.
Am I correct that you have reserved 2 minutes for rebuttal?
Correct, Your Honor.
Okay, when you are ready, you may proceed.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald Trump. This case is a textbook example of implausible allegations being propped up by highly inflammatory, inadmissible propensity evidence. As President Trump testified, he never even met Ms. Carroll and didn't know who she was until the allegations were made. There is no physical evidence, no eyewitnesses, no DNA.
I need to pause there. Do you hear where he said, as Donald Trump testified? He did not testify in this case. He testified in the second defamation case that related to his, even though it came second, it related to him defaming her while he was president. I'm surprised no one caught this, but I guess it was not all that important. Let's continue.
There is no physical evidence, no eyewitnesses, no DNA, no video, no complaint, no police report, no investigation. A quintessential he said, she said case that involves a plaintiff with a political motive to bring a story, who's funded and encouraged by President Trump's political enemies, raising decades-old, 40-year-old allegations, or decades-old allegations.
Your arguments are evident.
Okay, so now one of the judges, the first person you saw, this first judge I showed you, I have everyone's name up here, but in case you're listening and you didn't look, our first person there's 3 judges on this panel at the Second Circuit. We have the lead judge is Myrna Perez. The second judge that we're going to hear from is Denny Chin. And I'm going to show you our third judge. She comes along later. Hold on, let me find her. There she is, Susan Carney. Okay, so let's go back to where we were. We have Senior Judge Denny Chin, and he's going to say, hold your roll there. Slow your roll there, John Sauer. Why are you talking about the evidence that was presented and trying to get us to litigate facts? That's not what we do here. Okay, let's listen. Oops. Sorry, it does sound crazy. Hold on.
Versus Trump, that is 23-793.
Oh, man. I just realized something, guys. The way I have this set up, I'm not going to be able to pause. I will just have to shuffle through. It's not letting me. It just rewound this whole thing. Sorry.
Mr. Sauer, is that correct?
Yes, Your Honor.
Am I correct that you have reserved 2 minutes for rebuttal?
Correct, Your Honor.
Okay, when you are ready, you may proceed.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald Trump. This case is a textbook example of implausible allegations being propped up by highly inflammatory, inadmissible propensity evidence. As President Trump testified, he never even met Miss Carroll and didn't know who she was until the allegations were made. There is no physical evidence, no eyewitnesses, no DNA, no video, no complaint, no police report, no investigation. A quintessential he said, she said case that involves a plaintiff who, with a political motive to bring a story, who's funded and encouraged by President Trump's political enemies, raising decades-old, 40-year-old allegations, or decades-old allegations.
Your arguments are evidentiary issues, and as you know, we give great deference to the district courts on these matters. It's very hard to overturn a jury verdict based on evidentiary rulings. We use phrases like manifestly erroneous. So why should we order a new trial here?
Your Honor, I think for two reasons. It's very clear that there was error in the admission of the propensity evidence, so the Leeds testimony, the Stoynoff testimony, the Access Hollywood tape. As we pointed out in a brief, none of those are even remotely admissible under Rule 413 and Rule 415, which is the principal reason. And then
I'll go through these rules with you
404B
later.
argument they've kind of pivoted to after the trial. They argue that it was evidence of modus operandi. And of course, modus operandi evidence has to be used to show a proper non-propensity purpose, which they've never identified. So identity is not an issue here. Absence of mistake or accident, not an issue here. You have a situation. Sorry, Your Honor, go ahead.
You do agree, though, that Congress has passed Rule 413, 414, 415 to allow propensity evidence that would be excluded in other kinds of cases.
This is about sexual assault
permit
evidence.
its consideration by a jury in certain cases here.
Only if it meets the criteria set forth, in this case, 413D 1 through 5. So
Which
take,
it
for
does.
example, the Leeds testimony. That's the sort of 1979 story about the
this
airplane.
is 1 through
And
5.
again, it never happened, but assume that that the jury were to accept the argument. It has to meet those criteria. 413, for example, it has to be a crime under state or federal law. They've never even identified any statute that this conduct alleged supposedly violated, except for 49 U.S.C. 46506, a statute that was enacted 15 years after
There's that
the
statute.
allegation in place.
What about
Don't be fooled
the
by
rule
him.
of evidence D5 and 2, 5 being an attempt, 2 being contact without consent between any part of the defendant's body and another person's
There it is.
genitals? If the defendant, assuming it's true, put his hands up her skirt, why doesn't that qualify?
That would, I think, the case law
Why
here.
wouldn't that be an attempt to engage in that conduct?
The case law, I think, on attempt is very strong for us, and I think decisively rejects that. I point to the Hayward case from this court, the Rogers against State case from the Florida Supreme Court, and other cases. For example, if you look at the facts of the Hayward case, they're facts that are just
But if you
egregiously beyond
if you
it.
look at this case, is it manifestly erroneous for Judge Kaplan to say, yeah, this is at a minimum arguable, and we'll let the jury decide?
Well, as we argue in our brief, the proper standard of review when it comes to a legal error on the interpretation of Rule 413 is de novo. But it's erroneous under any standard of review. Because if you compare it, for example, to the egregious facts of the Hayward case and the Rogers case, even what was alleged, which I emphasize never happened, even if it was alleged, it would be anywhere close to fact patterns that this court has rejected as attempts, and also the Florida court as well. Yes, Your Honor.
I just want to take a step back. My understanding from both of the papers is that our court has not yet ruled on what is a standard of admissibility for under Rule 415. Both of you cite to Third Circuit law. Is that correct?
That's my recollection of their
in
brief,
your
yes.
view that this is a question of first impression for us?
On the standard of admissibility for Rule 413, it depends on which of the issues we've raised. Some of them are
Again,
addressed in other circuits, and some are
I'll
not.
explain what these rules
By and
are.
large, the arguments I've been addressing now
It's
are
just about
questions of
sexual
first
assault
impression from the
evidence.
Second Circuit. However, we point to case law from other circuits that's
So
very.
is there anything about the Third Circuit's understanding of what this admission standard is that you would have us depart from?
Not that I can think of, but there are multiple Third Circuit cases. I want to be careful how I answer that, because there are multiple Third Circuit cases citing the brief, and there may be things in some of them that we disagree with. Overall, the standard of admissibility is what's set forth in the plain
Okay, so
text
I
of
just want to make
413.
sure the standard that you believe that we should be dealing with is a reasonable jury could find by a preponderance of the evidence. Is that correct?
Yes, we have not disputed that in our brief.
This
That's
means
correct.
that you
And that
cannot
is the one that you
overturn
believe that we need
this
to
verdict if a reasonable jury could have believed.
I would say we have not disputed that in this case, is the way I'd frame it. And again, that standard, however, In this situation, we're dealing with interpretive questions as the meaning of phrases in 413, D1 and D5 and D2. Those, for example, are pure questions of law that are subject to de novo review. That's not a situation where a reasonable jury can determine whether or not something legally constitutes an attempt, for example. So
he's trying to take it away from the jury.
If you look at the Stoynoff...
he thinks they shouldn't have been able to hear this evidence.
Leeds testimony.
Sawyer, you're speaking so fast.
I apologize, Your Honor.
Slow down a touch.
It's an important case, and I'm passionate about it. The Leeds testimony, for example, we've argued that the Leeds testimony was inadmissible.
She was the one assaulted on the airplane.
For example, D1. D1 says conduct prohibited by Chapter 109A. Every federal statute in conduct, Chapter 109A has a federal jurisdiction requirement. That's an element of the offense. That says within the territorial and maritime jurisdiction of the United States or similar language.
What do you make of other statutes where the phrase conduct prohibited by is used as distinct from jurisdictional requirements? For example, 18 U.S.C. 2332 GB also has the conduct prohibited, but they also have a jurisdictional statement. Like, how are we supposed to take your argument in this matter? Like, isn't this also an area of first impression for us that we have to decide whether or not the jurisdictional elements are incorporated?
And it is one that where there's clear guidance from the U.S. Supreme Court, for example, in the Omni Capital decision that we cited, as well as the Hart versus Reliance Insurance cases, where the Supreme Court says, look, when Congress
this is a case about sexual assault and defamation. This is what happens on appeal, guys.
The inference that that's not what they intended. And we cited, at least as Your Honor points out, 6 federal statutes.
Doesn't that presume the acceptance that conduct also incorporates a jurisdictional requirement? They use the words prohibited conduct as opposed to.
I will explain in a moment. You'll hear why this matters.
So if you could just hone in on that particular component of it.
Yeah, and we point out the plain meaning of prohibited is to forbid by authority or command. In Chapter 109A, Congress has not prohibited conduct that doesn't occur in certain federal enclaves, essentially.
These statutes were intended to allow, contrary to common law, evidence of regarding conduct that was serious, of a serious nature. And I'm not sure how the jurisdictional element, the precise jurisdictional element, whether in an airplane in the specific maritime jurisdiction or what have you, impacts the conduct that Congress was willing to let juries consider in adjudicating these kinds of cases. Could you address that concern?
Sure. I'd say 2 things in response to that. First of all, Congress' intent is best reflected in the plain language of the rule that it enacted. That rule says it has to be conduct prohibited by 109A, and there really isn't a good argument that means.
It doesn't say that,
conduct that, if
I'll
it had been performed in special maritime and territorial jurisdiction, would be prohibited, which is what they argued it means. And one powerful evidence of that is there are 6 federal statutes where Congress said exactly that. They said conduct that, Your Honor, I see my time's expired. May I
Thank God.
You may finish, but then move on.
Okay. And so there are 6 federal statutes where they said exactly that, conduct that, if it had happened in these federal enclaves, would be prohibited. Here they did not say that, and the compelling inference is it's not what they intended.
Okay, thank you so much. We'll hear from you on rebuttal. We appreciate it. If you don't mind, Ms. Kaplan, starting from...
I promise I will unpack this and make it simple. The bottom line is they don't want Jessica Leeds' testimony to come in because it happened on an airplane, and they're saying, therefore, it's not the kind of evidence that can come in. We'll talk about that in a moment.
Eugene Carroll, appellee, may it please the court. I don't believe Your Honor does have to decide the jurisdictional issue. You could decide it here, Judge Perez, but you don't need to. And the reason is because there's a federal crime now, independently of what Mr. Sauer talked about, that prohibits sexual contact in the special aircraft jurisdiction of the United States. I'm sorry, Your Honors, I've become an expert on aircraft jurisdiction now. And even with respect to Mr. Sauer's argument, which he raised for the first time on reply, that there wasn't a statute in 1979, there was a statute in 1979. It prohibited assault on a plane. And what Ms. Leeds testified that Mr. Trump did on that plane was clearly an assault. So you can decide the jurisdictional point, but I don't think you need to for those reasons. Your Honors, taking it back a little bit, despite the prominence of this case and the parties involved, it really just involves the routine application of the federal rules of evidence. That application was performed by Judge Kaplan, who has many years of experience trying cases, And just so the record is clear, who is neither related to me nor is my mentor. E. Jean Carroll brought this case because Donald Trump sexually assaulted her in 1996 in a dressing room at Bergdorf Goodman, and then defamed her in 2022 by claiming that she was crazy and made the whole thing up. After a nearly 2-week trial, the jury found in Ms. Carroll's favor. At trial, we called 11 witnesses. They included Ms. Carroll, who testified for nearly 3 days straight, most of which was cross-examination. And here's what she said. Question: when you're fighting and being sexually assaulted and raped, because you are not a screamer, as you describe it, you wouldn't scream.
I'm sorry, I just want to make sure that we're going back to the evidentiary issue.
Sure.
So I count that we have been asked to consider 3 questions of first impression. One of them was one thing that you mentioned a moment ago about whether or not 415D must have been a crime at the time that the crime was committed. Is that correct? And then the jurisdictional question about whether or not the requirements of 109A have been incorporated by D1. Your opposing counsel cites a judicial council recommendation, which Congress did not adopt, that would have added clarifying language to Chapter 109 to have made it crystal clear that the jurisdictional component was separate from the conduct component. What do you make of that?
I make, Your Honors, as we always do with legislative history, is that Congress rejected that. And the Violence Against Women's Act, which is these evidentiary rules grew out of, are one of the few evidentiary rules that were actually passed by Congress. This didn't come from a rules committee. This came from Bob Dole and Susan Molinari of Staten Island, and it was part of the Violence Against Women Act. So to me, that obviously only cuts our ways. And let me just be clear about what Judge Kaplan held here, because I think its clarification would be helpful. As Judge Kaplan held, Trump's conduct is a federal crime because it violates 49 U.S.C. 46506. If you go to 4600506, well, before I get there, under 43D2, it was an attempt, it was a sexual contact and an attempt at sexual contact. Section 46506 makes it a crime to do certain things on an aircraft, and here's my favorite phrase, in the special aircraft jurisdiction, that if committed in the maritime and territorial jurisdiction of the United States would violate provisions of 18 U.S.C. In other words, Section 46506 takes certain parts of the U.S. Code and says they're a crime on an airplane. As Judge Kaplan found, Section 46506 cross-references 18 U.S.C. 2244A1, which covers knowingly using force to cause or attempt to cause another person to engage in sexual contact. Sexual contact is defined as touching directly or through clothing the breast or inner thigh of any person or intent to do the same. What you hear from Mr. Sauer is that doesn't count because in 1979, that wasn't a crime. And that's the argument they first raised on reply. But the answer to that is it was a crime in 1979, and this is a new statute without our brief because we didn't have a chance to respond to it. In 1979, the predecessor was 49 App USC Section 1472K, and under that section, it was a crime to commit a simple assault on a plane. And there are multiple cases, including the Bays case.
Sorry, I thought your opponent said that the predecessor crime was actually rape.
That's what he said.
That's incorrect.
That's incorrect. The predecessor crime
simple assault
is a simple assault on a plane, and in the Bays case in 2000, the First Circuit held that that simple assault includes a guy who was on a plane and, smacked the stewardess's tush as she was coming up the aisle.
Assuming there is jurisdiction here, back to the facts of the Leeds case, why isn't it very different, substantially different? It occurred on an airplane, which makes it very different from the other incidents.
Look, I think let me put it this way. The fact that this was on a plane, Judge Chen, has inserted all kinds of complexity in this case. It's actually not that complex. It was a crime then to grope someone on a plane. It is a crime today to grope someone on a plane. And as I said, I was thinking this morning, this may be a situation where you have too many lawyers trying to screw in a light bulb. You don't have to get to, it clearly was a crime.
No, I'm assuming for these purposes it's a crime, but the fact pattern is different from the other incidents, which were in much more private places.
So
is it does that make it too different to be relevant?
I
mean,
would-
the probative value becomes less.
So I would concede that unlike Ms. Stoynoff, Mr. Trump did not lead Ms. Leeds into a private part of the plane. That's for sure true. But the rest of the pattern is exactly the same. He had a pattern of having kind of pleasant chatting with a woman, kind of, E. Jean Carroll even testified that it was almost flirtation, very pleasant chatting. And then all of a sudden, out of nowhere, he would, for lack of a better term, Your Honors, pounce. And that's exactly what happened with Leeds on this plane. He didn't let her out of it when she tried to squirm out. She ultimately succeeded. And then, to finalize the pattern, once these three brave women came forward and said what had happened to them, he said the same thing about all three of them.
So what if we just say that you're wrong on this, that it's too remote, it's too unlike the circumstances that your client alleged? What assurance can we have that it didn't unduly affect the jury's verdict?
So, if you're talking about Jessica Leeds.
Yes.
So, you obviously
the
look...
airport, the remoteness in time,
Right.
the difference in
You look at it,
circumstances.
as I said before, in a manifest injustice standard. And I was going through the evidence at trial. It was incredibly powerful. Not only did you have E. Jean Carroll, you had two outcry witnesses who she told immediately after the assault, who both testified, one of whom is in this courtroom today. You had two people who were former employees of Bergdorf Goodman who did not know E. Jean Carroll, but who corroborated fundamental facts about the operations and the layout of Bergdorf Goodman back in 1996. You had a psychological expert who's an expert on trauma, Dr. Lebowitz, who, at Mr. Trump's counsel's question, was able to say that she believed Ms. Carroll and that Ms. Carroll wasn't malingering. She also described...
I'm sorry, so I just want to... I'm sorry, go ahead.
But the witness you're describing is someone who heard a report as opposed to was a witness of some kind. But please go ahead, Judge.
No, I was just going to ask, so is it your position, and it sounds like what I'm hearing you, is that you could lose all of the propensity evidence and you still would think it would be harmless error? Like, are all of the questions that we're talking
I
about
believe I
right
could
now
lose
harmless?
all the propensity evidence and still be harmless error, except that the Access Hollywood tape, as Judge Kaplan noted in his post-trial motions, is better admitted as a confession. Party statement. He said, this is what I do. I grab women by the pussy without their consent. It was after what he did to E. Jean Carroll. And we cite the case in our brief where a guy says, I'm a drug guy.
Well, wait a minute, is
And
the
that was
harmless
enough.
error standard harder for you because of the clear and convincing burden of proof on the defamation claim?
No, because this is all about the assault, Your Honors. In order to prove defamation, we talk about in rejecting the categorical approach under 415, as Judge Kaplan, as Judge Furman, and as every other circuit has decided it has said, there's an overlapping factual element, but it doesn't mean once the actual element is found, as it was found here on the battery claim, it doesn't mean it changes the evidentiary standard, and it wouldn't convert it into non-harmless error. If I answered your question. You're looking at me like I may not have.
I'm thinking.
On top of all that, you had Donald Trump's own testimony. Now, Mr. Trump is here today.
And this is winding up
He was
now.
given every opportunity by Judge Kaplan to show up at this trial, and he was even given till 5 o'clock p.m. on the Sunday before closings, and he didn't show. He had every opportunity to take the stand and rebut all this evidence. He did not. He did not put on a single witness in the civil case. We put on 11. But what we did put in is this videotape of Access Hollywood where he basically says, I grab women by the pussy, excuse my language, without their consent. And then at his deposition that I took and asked him about that video, what did he say? He embraced it, Your Honor.
Thank you for your time. We appreciate it. Mr. Sauer, you've got 2 minutes.
Thank you, Your Honor. Just to turn to that harmless error point, the standard for harmless error is the court has to have a fair assurance or a conviction that it did not influence the jury, and that argument really can't be made with a straight face here. I would point the court to...
Why is that? I mean, I noted a conspicuous absence of reference in your briefs to the so-called outcry witnesses, to Ms. Bernbach and
Bernbach.
Woman who
Carroll Martin.
has been spoken to at the roughly contemporaneously. So why isn't that enough? That confirmatory evidence that's contemporaneous with the event.
Yeah, I'd say 2 things that sort of make that not a strong argument for them. One is the outcry witnesses had egregious bias against the defendant. Their prior social media posts and text messages said things totally unrelated to this case based on his politics, said that he's herpes we can't get rid of. He's compared to
But you had an
Putin's
opportunity
stooge.
to cross-examine them in front of the jury, right?
Yes, but the question in harmless error is what harmless error is not could the jury believe it, but was the jury's judgment about that tainted by the fact that they also heard all this inflammatory evidence? And one thing that this court and other courts emphasize is how did the plaintiffs use it in their opening statement and their summation? And here they relentlessly hammered the propensity evidence, the Access Hollywood tape, the Leeds testimony, the Stornoff testimony. If you look at the summation,
I looked at the opening sentence, at the opening statement and the summation, and I didn't see the relentless hammering that you're describing.
See?
I saw
He's lost
mention of it,
credibility.
but also emphasis on the outcry witnesses.
there is discussion of the outcry witnesses, but for example, look at the summation. The first 4 pages of the summation go through Access Hollywood, Leeds, and Stornoff before they ever even get to Carroll's own story. And then if you go to the end, they emphasize it again, and it's emphasized again and again.
How do you respond to the argument that the Access Hollywood evidence is different from the propensity evidence? It's not propensity evidence. It's really a confession.
Sorry.
They've argued
That
it's
was
propensity
Chin.
evidence in their brief. They say it's
Trying to get to
propensity.
Chin.
And it's hard for me to...
What about the argument, whether it's new or not, that it's not propensity evidence, but it's a confession? How do you respond to that?
It's hard to see how it's a confession because that's the underlying problem with it is that they don't point to any specific incident that it's a confession of. And so for them to speculate...
Well, it's a confession
I will.
about
Don't worry.
a
I will
modus
explain it.
operandi.
Clock.
But modus operandi itself is inadmissible, and a confession to a modus operandi to be admitted and not be sort of so prejudicial and inflammatory, which is what it was and how it was used, is just not something that is admissible. It involves speculation and conjecture to assume that it relates to any specific incident when they've never identified one. I see my time has expired.
Thank you so much. We appreciate it. We will take this case under Carroll versus.
Okay. Thank you, guys. I really thought I'd be able to pause it for more than a moment without it restarting. But the good news is I am here to explain to you what the F that was about. And I hope you appreciate what an amazing lawyer Roberta Kaplan is. And I hope you also understand that lawyers don't just argue cases in front of a jury, but appellate argument is an entire specialty. And you have to be quick on your feet. And you also have to seem to be intimidating, as Sauer is. But I'm going to walk you through what this is about, and it won't take me long because it's pretty straightforward. So we know, as I said, this is about the first trial that was brought against Donald Trump in which a jury found that he had both sexually abused her in the Bergdorf Goodman dressing room, as well as committed defamation when he said that he never met her and that she was lying and she was doing so to try to sell a book and the like. Okay. Remember that his main arguments in his initial brief were that, let me just also remind you, you don't get to appeal the verdict itself. You can only appeal if there is some kind of legal error that the judge made. And there's all manner of things that people can claim, but what they argued here was that Judge Kaplan should not have allowed evidence of that testimony by Jessica Leeds, who said that she was assaulted on an airplane I think it was in 1979 or 1980. Secondly, that this is also part of the first thing, that they shouldn't have allowed the evidence in Natasha Stronyov's testimony that she was assaulted at Mar-a-Lago in 2005, and that they shouldn't have allowed the audio, essentially the audio tape of Donald Trump saying that he grabs women by the pussy, the thing that he said in the Hollywood Access tape. They also argue that Kaplan should have excluded should wrongly excluded certain evidence, and they wanted to bring in that Anderson Cooper video and also say other things that were really irrelevant to the case. And then the point here was that overall, in doing so, that he was deprived of his rights and needed a new trial. What E. Jean Carroll, of course, said, even if mistakes were made, the standard here is abuse of discretion. And even if there was some evidence that should not have come in or evidence that should have been allowed to come in, it did not affect the jury's verdict. And so he doesn't need a new trial. Now, what were they fighting about here? and I'm going to pull this up. They're fighting about the testimony of certain witnesses. And in this case, this is here Jessica Leeds. And she testified in the spring 2023 trial that she had been accosted on an airplane by Donald Trump in either 1979 or 1980. I think it's 1979. The reason why I said 1980 is I had this information from my original NPR interview. So if it was 1979 or 1980, that's why they keep talking about the statute. They're saying that because she was assaulted, if she was, first of all, they're denying it, but they're saying even if what she says is true, because it happened on an airplane, they're claiming it was not admissible as evidence under the federal rules of evidence. I swear to God, that's what they're saying. I'm going to walk you through why that's BS. They also didn't want Natasha Stroynoff to be able to testify, but that didn't come up on appeal. So it doesn't seem like anything specifically that they was specifically focused on. Remember, she was a People magazine reporter who was down at Mar-a-Lago, and at one point Donald Trump was giving her a tour. He took her into a room, pushed her up against a wall, and forced her to kiss him. That attack was very similar to what he did to E. Jean Carroll, and also felt her up, etc. Of course, this is the other thing they don't want to come. They think was an error to bring in was a Hollywood access tape. And the difference here on this is they keep talking about how they wanted to treat that not as his propensity to assault, but actually as a confession that he had this MO, this modus operandi of just starting to kiss women and grabbing them by the pussy, which is essentially, I'm sorry to my friend E.G. Carroll, what he did to her. Okay. They don't want that coming in. Now, let's just go through this because this is so basic and it gets scary when someone says, Rule 413, 415. It sounds like they're throwing out like football plays. You guys, this is so basic. What's not basic about it, the only hard part about this is that the Second Circuit has never ruled on some of these interpretive issues. Okay, that's the only hard part. So the main rule of evidence, guys, that we're talking about, and I feel like I'm in a law school classroom and I'm so sorry, but I think you'll appreciate this after wondering what the F they're talking about, because it seems like common sense that you would be able to get evidence of this similar sexual assault or sexual attack to be in evidence. So let's first talk about Jessica Leeds, because that's the one they focused on. Okay. So here's this rule of evidence, and it says it's 415A, and it says in a civil case, which what this was, civil case involving a claim for relief based on a party's alleged sexual assault or child molestation, the court may admit evidence that the party committed any other sexual assault or child molestation. This was enacted by Congress as part of the Violence Against Women Act, okay? Most of the federal rules of evidence, as were noted, are sort of done by a committee and then sort of like blessed by Congress wholesale. So this was passed so that it could come in. Now, so this rule of evidence, 415, is the main one that has the standard for admissibility has not been decided by the Second Circuit. What does that mean? What they were talking about is it means, kind of whether the evidence, whether it should go to the jury or not. And what they were talking about, the standard being in a nearby circuit, the Third Circuit, was whether a reasonable jury would find by a preponderance of the evidence, that's more likely than not, that this was a similar sexual assault. And I'll explain that. Okay, so first of all, the number one thing under 415 is saying you can do this, but it says it's subject to rules 413 and 414. So what does that mean? This is the key thing. This is not blanket permission to bring up any alleged sexual assault. It's not. Here is the limitation on that. The limitation is in 413A. Now note that this refers to criminal cases, but don't worry. 415, which is the civil rule, said, look at this. Look at this one. And what it says is that, and this would apply to a civil case, in E. Jean's case, essentially, where a defendant, Donald Trump, is accused of sexual assault, the court, meaning the Judge Kaplan, may admit evidence that Donald Trump, the defendant, committed any other sexual assault. And here's the limit. The evidence may be considered on any matter to which it is relevant. And what you have to know about relevant is, of course, it's relevant that he allegedly sexually assaulted someone else, and her testimony is relevant. The question is whether it would be too prejudicial to be probative, too inflammatory. And I don't think anything was said about that. Now, also important is below, and this, I didn't give you the whole part of this statute, but sexual assault is defined as an attempt. So an attempted sexual assault. So again, E. Jean was sexually assaulted. Jessica Leeds, he did reach his hand under her skirt and touched her legs. That could be defined as a sexual assault, but even if it wouldn't be, it was for sure an attempt, etc. Okay, that's what we're talking about. Now, the last part, and this is sort of the key provision here. The last part here is when you can use evidence of other crimes and wrong acts. This is the 404B aspect. This is what they were talking about, the Hollywood access tape. Now, generally speaking, you cannot use evidence of any other crime, wrong, or act. So something wrong, like him saying he grabs a woman by the pussy, it's not admissible to prove someone's character, to show that they're the kind of person who does this. You're not allowed to admit that for that reason. Saying, well, he's the kind of person who does this, therefore he's likely to have also done it to E. Jean. It can't be admitted for that reason. However, evidence of another wrong or act can be admitted for the purpose of proving motive, opportunity, intent, preparation, plan, knowledge, and so on. So the point is, that's what Judge Kaplan was saying. It was fine to bring in the Access Hollywood tape. So just the bottom line here is, what they're trying to do is not allow, there's one more piece to this, I'm sorry. Not allow this testimony to come in. Now, there's one last thing I got for you. There's one piece of this. This is it. Okay, so this is the part in the Federal Rules of Evidence. This is Section D. So this is Section D. I think it's 414D. Or it could be 415D. I apologize, but this is the one that is the most important part of this. So remember, generally speaking, it's fine to bring in prior evidence of sexual assault if it's relevant when a defendant is being accused of sexual assault. But they deal with this definition of sexual assault that I was telling you about. Yes, I'm sorry. This is a section that gets pointed to. This is 414D. So even in a civil case, you look to this. Now, this is the key thing that they were fighting over, you guys, and it's really kind of infuriating. Okay. This says that sexual assault for purposes of this kind of evidence means a crime under federal law or state law involving, and it's any of these things. It says 1, 2, 3, or 4. 1 is any conduct prohibited by 18 U.S.C. 109A. This is the one that they say, because it happened on an airplane, it doesn't work. Because that statute, they're saying it excludes that. Okay, fine. Then they've got 2, 3, 4. And this is 2 is the one we are talking about. Contact without consent between, 3, contact without consent between the defendant's genital. I don't want to read this. But anyway, contact without consent between any part of the defendant's body, that would be Donald's body, his hands, his fingers, and another person's genitals. That is what they're talking about. And also, so you say, okay, that's what happened to E. Jean. Sorry, guys. But what about Jessica? What also there, to be clear, is that last part that says, I'm trying to get this to be large enough, that last part that says, an attempt to do anything 1 through 4. Okay, here I'm going to make this go away now. So the bottom line is this whole appeal, which they are going to lose at the Second Circuit, is that Judge Kaplan shouldn't have let the Hollywood Access video in because it just, it's the wrong kind of propensity evidence. It goes to his character as opposed to any kind of, as opposed to going to this idea of his MO. That it's not, I'm sorry, as to being a confession. Confessions are allowed in, even if it's about an MO. They say this wasn't a confession. The other thing they don't want to come in is Jessica Lee's testimony, because they're arguing some arcane interpretation of this statute that somehow, because there wasn't a federal law at the time he assaulted her that said you can't assault someone on an airplane, their claim you can't sexually assault someone on an airplane, therefore this doesn't count. This is all kind of dancing on the head of a pin, because Robbie pointed out there was a statute that forbid, physically assaulting someone on an airplane. And as you know, Donald Trump was found liable not just for sexual abuse, but for physical assault. I am so over these details. Okay, guys, so that's the bottom line here. This is where we are. This is, again, why people with deep pockets can try to defend the indefensible for as long as they want. And thank God E. Jean has a lawyer like Robbie Kaplan, who I'm sure you saw is utterly, utterly brilliant. Now, I don't know how long it's going to take for the Second Circuit to rule, but they are going to reject his demand for a new trial. Even if they decide some of this evidence shouldn't have come in the way it did, maybe they will on the Access Hollywood tape. I don't think that's relevant because it didn't come in the other trial. I don't think they're going to say that it was substantially harmed his rights. They're not going to give him a new trial. And if this goes up to the U.S. Supreme Court, I believe it will be the same story. I think they are going to, throw out his appeal. And once this case stands up, then we get to his appeal of the other verdict, which is closer to $90 million. Okay. Now, one last thing on this is in his ridiculous press conference, Donald Trump essentially said, yes, I rape people, but Jessica Lee's and E. Jean Carroll would not have been the chosen ones. That's what he said, guys. And remember, there is in the video deposition, Donald Trump looking at that photo, which I am sure you have seen before. I'm going to show it to you now. It's at the very end here. This photo of E. Jean Carroll speaking with Donald Trump, and her husband is there. Sorry, I'm going to find it. It's the very end of my slides. She is standing there shaking his hand at some event in New York City around the time of the assault. And it's taking me a while there it is. And let's just look at that. This is this photo. Donald is on the left. We can see E. Jean facing him, E. Jean's husband at the time, John Johnson. And then there is Ivana. When he looked at this photo at the deposition, and it's on videotape, and they said, who is that woman? Donald Trump said, that's Marla. E. Jean Carroll is a gorgeous woman at any age, but she was not only his type, she is the kind of person that he would have raped, and he did. And I hate saying that, but it is a fact. Okay, so one last thing before we get to Crazy Town is this. Yes, you do need to know, and I think you probably already know, that the sentencing has been postponed by Judge Juan Merchan in the state criminal case for which Donald Trump was found guilty on 34 counts. Whether this is a good or a bad thing, that might be, the beauty, that is in the eye of the beholder. I think I might have made a different decision, but at the end of the day, it is a sound decision and the right one, in that Donald Trump, I know it's right because he's angry about it, but also it implies to me that the judge is doing what a judge would normally do in this case. There are other reasons why sentences are postponed. He should not treat Donald Trump any differently than anyone else who asks for a postponement. Furthermore, the judge is honest that this is something of first impression. This is a former president, someone who's a candidate for federal office, and that the jury worked very hard in coming to a verdict. What this also means to me is that if Donald Trump actually loses the election, which I hope happens and is likely but not guaranteed, I think the judge will be less pressured not to give him some kind of custodial sentence, whether that is incarceration in a facility or some kind of electronic bracelet or both. Okay, now it is time, my friends, for Crazy Town. And of course, this Crazy Town is Donald Trump, and it is nutty. I want to dance, but I fucking hate this man. So, if you didn't think Donald Trump hated women enough, did you hear his plan yesterday? The position he's going to give to RFK Jr., the man who arguably drove one of his wives to suicide, who had cataloged all the extramarital affairs he had in a diary that she saw. He was an awful person, not to mention his propensity for killing wild animals or finding them and bringing them home on the top of his car. Do I need to go on? Also a vaccine denier, etc., etc. Here is his plan for RFK Jr.
Court ruled today that Robert F. Kennedy Jr.'s name should be taken off the ballot. And
not in every state. That might have been North Carolina.
And that sounds like a bad thing for him. It's not. It's actually a great thing. He's an incredible team player.
Ugh.
And he didn't want anybody to be voting his name because, as you know, he fully endorsed us. He's with us. He's going to be watching out for women's health and everybody's health, and got a lot of great things to say. He's very smart.
Women's health. RFK Jr. in charge of women's health. It's crazy out there, guys. I don't know what to tell you, but thank you for being here to support our hero, Eugene Carroll, and learning a little bit about law. I will see you guys on Monday. Have a great Sunday. I hope there's no breaking news because we will have to wait.